Welcome to part 3. We're going to talk about other important stuff. Let's think about family fights. I understand that your family gets along just fine, and it's only all those other families would ever have one of those family fights. But that's because you're alive. After you die, things change. So it's nice to have a way to resolve family fights with dispute resolution provisions written into your documents. What I do is prepare these documents and say that if there's a dispute, the first thing they're going to do is mediate. Mediation means that they're going to get a trained person who knows how to get people to get along, sit down the opposing parties, and see if there's any way that they can make this get together without being nasty. And there's a reason for this. Absent provisions like this, the unhappy party will usually go to a lawyer. When they go to a lawyer, they will have to pay money. Once they pay money, the position that they hold becomes entrenched. And now you're going to have continuous self-justification and confirmation bias in whatever position these people have taken. The idea is to defuse this before they get to the entrenched position that's going to lead to litigation, and try to do it by agreement. That's called mediation with a trained mediator. I have not done a study of this, but I would guess, using Professor Pareto's old 80-20 rule, probably 80% of the cases that would otherwise be litigated and are miserable end up being settled through the mediation process. For that 20% that doesn't make it, however, we still can avoid a court. And the way to do that is through an arbitration. There are several ways to do an arbitration. My way of thinking is the easiest and best is each side picks one person. Those two people then pick the third person. The third person becomes the presiding arbitrator, and they render their decision. They listen to all the sad tales of woe, and you're still not going to court. The beauty is that they don't have to follow all the technical rules of evidence and procedure that you have to follow in a courtroom. And they would then resolve through their arbitration procedure what happens. Once they do, in arbitration, it's called an award. In a court, it would be called a judgment. You take the award, assuming everybody says, okay, this is what it is, I'll live by it. But assume that they don't do that. The ultimate step is you take the award to the court, and it's a mere filing procedure, and the award becomes then a court judgment. So we've now saved a lot of time and money going through this. And I have to tell you that I'm a litigator. I've been doing courtroom stuff for decades. And not only is a litigation, even small ones, more expensive than most heart transplants, it's much more emotional than most people can ever imagine. Avoid it if there is a possible way to do so. Let's look at taxes and probate. Keep in mind, these are not related. I often bring this up and repeat it because there's so much confusion with it. Taxes and probate are not related. Probate, remember, it has a purpose of transferring title after your death. Taxes are different. They're supposed to support politicians. You know, I know. A lot of people think that taxes go for such things as schools and libraries and streets, and that's way too naive. The real purpose of taxes is to support the political class in the fashion to which they have become accustomed, and they enjoy it. On taxes, let's talk about the death taxes. I promised I'd come back and talk about death taxes, and here I am talking about them. I have good news when it comes to taxes. Death taxes do not apply to most people. Now, there's something happy. But there are taxes who do, or which do. And we have two types of death taxes, not just one. We have the estate tax. The estate tax is a tax on your right to die. I know a lot of people thought they could just kind of wander down to the mall and fall over dead and that was the end of it. But it isn't true. According to tax law, that's the estate tax, the government, and you're going to love what I'm going to illustrate in just a moment, the government claims that it owns everything you have at the instant of death, including your gold teeth. However, politicians are interested in really three things: getting elected, getting reelected, and getting reelected. What politician would be elected or reelected if they pushed that law to the end? So what they do is that they allow an exemption. They actually allow you to keep some of your own stuff. What people? In the federal level, they allow you to keep $5 million as of 2012. Now that can change. It can change in 2012 because the politicians have until December 31 of 2012 to make it retroactive to January 1 of 2012. So you're not safe until January 1st of the next year of knowing what the estate tax exemptions or other laws will be. Because it might change, you're always in danger. The state tax. Oh, state estate? Yes. It's almost a tongue twister. You can have a federal estate tax or you can have a state estate tax. Interestingly, the state estate taxes are based on the same concept as the federal estate tax. In other words, they claim everything too. Isn't that interesting? Fortunately, neither one of them claims enough to get it all. It's sort of like the Sharks and the Jets. I think they have some sort of an agreement, tacitly understood, that they'd never take 100%, because otherwise the states would be fighting the feds over it. The estate tax, well, some states have one. Approximately, I'd say a third of the states have a state estate tax. Predominantly, you'll find this in the northeast of the United States. Places like Massachusetts, they're famous for this. New Jersey, New York, Pennsylvania, all of those states, all will have a state estate tax. So if you're subject to the estate tax, you could be paying the federal and state estate taxes. Other states do not have an estate tax. So what's this tell you? Well, when you feel a little death coming on, you want to go to one of those states that does not have a state estate tax. A state like Arizona. We don't have a state estate tax, and so as I tell people, this is a good place to come die. The second type of tax is the inheritance tax. Whereas the estate tax is a tax on the right to die, the inheritance tax is a tax on the right to receive. Get the concept difference here. You move to Arizona and you fall over dead, but you left things to somebody in Massachusetts. Massachusetts has an inheritance tax. So the person you gave things to in Massachusetts is going to pay a tax to that state based upon the value of whatever it is you gave to them. That's why it's called a tax on the right to receive. Well, I've got some good news here too. I always like to bring good news with the bad. There is no federal estate tax. Zero. None. But there's also bad news. Congress is still in session. As to which states have an inheritance tax? Well, as I say, some do, some don't. About half the states have an inheritance tax. You can even go farther west. You can go to places like Kansas, places such as that, and they do have an inheritance tax. Predominantly you'll find in the Southwest, you will not find states that have an inheritance tax. So these are good places to come if you're passing on. The other states, like Arizona, do not have an inheritance tax. Another document, again separate from the trust, and this is different from, say, the powers of attorney. It's different in this way. The statement of wishes has absolutely no legal effect at all. None. The others do have legal effect. This one has no legal effect, but it's very important. For example, let's say you have 2 children, and you're leaving half of everything that you have to the 2 children. That's how you say it, half to each. Well, how do the kids know what to put in each share? So here on the statement of wishes that is not binding, you can say what you think is going to be best. For example, you would say, I want you to take the archery equipment, my guns, the fishing equipment, the kayak and the canoe and the camping equipment like tents and things. That all goes to my daughter. All of the dolls, the doilies, the little things, the knickknacks on the shelf go to my son. And that way the kids will know what they should be getting. Now they might want to switch, or they might be one of these modern families that's just fine. Either way, you can tell them what you think there ought to be put in each of their shares. Another thing that's important with a statement of wishes. You know where everything is on your bookshelf or safety deposit box. They don't. So what you should do is tell them where to find documents. And you should also tell them where to find assets. Remember, I mentioned earlier that sometimes estate planning is nothing more than leaving a treasure map. Well, that's true here too. So you need to say, okay, everything here is in the trust, but you don't know where everything is. Here's a list of where I buried the stuff. Give them that stuff. You also need, in this statement of wishes, you need to tell them all kinds of personal information. Let's say you're leaving them with a dog or a cat or a fish bowl or something. How often do you feed the fish? If you've left them with a pet snake, how many mice a week do you want to feed them? Do you walk the dog where? Who's the veterinarian? All kinds of things like this have no need to be in a legally enforceable document, but they certainly make the administration much easier for your successor trustee. Assuming that you have not made plans with biomedical resource thing, or some medical school, and you do want to have a cremation, and you have not made plans, pre-need plans, there is one other thing you need to do. You need to get a cremation directive. The reason is, under Arizona law, if somebody objects to your being cremated, and you don't have one of these, then you won't be cremated. But if you've done a pre-need, that's part of the paperwork, and if you have not done a pre-need, then as part of your estate plan, you do need to have a cremation directive. This puts you in control. It says who gets your remains and basically takes care of all the things you need to know. I'm going to switch now from all of that sort of stuff into how you hold title to property and a little bit about capital gains. To do that, I need to start with community property. People who are not from the Southwest have no concept, or usually if they have any concept of community property, it's a misunderstood concept. So I'm going to talk about it so that you'll understand it and understand how we use it in community property. In estate planning. First of all is the heritage. You probably know that most of our law in the United States is from England, common law. And we get a lot of our common law from France, as a matter of fact. An interesting trivia thing that you may want to pull on somebody is, until 1650, which is not that far ago, until 1650, French was the official language in the British courts, not English. But where do we get community property in Arizona, or Texas, or New Mexico, or California? Well, I've had people say, from France. And I tell them, well, maybe indirectly. One person told me from Louisiana, but that's not the answer either. Actually, we get French law in Arizona from Mexico. And we get it by reason of the Mexican-American War in the 1850s, which was a trumped-up war if you go look at the history of it, during a time of manifest destiny when we were destined to take over all of the northern hemisphere here. But in settling that war, we settled it with the Treaty of Guadalupe Hidalgo. And the Treaty of Guadalupe Hidalgo said everybody north of the border, which is the same border we have today, everybody north of the border who used to be Mexican citizens will now have the same rights as they had as Mexican citizens, even though they're U.S. citizens. It's part of the treaty. Well, that's kind of interesting because women under community property law were equal to men. My wife is French, and let me tell you, they can tell you that the French have always had this principle that women are equal. But not so under British law. In fact, in Arizona, when I was in law school, married women could not even enter into a contract. That's during my lifetime. They overcame that eventually. But going back to the French law, the French women had rights, British women had none. As a matter of fact, under the British law, when a man and woman got married, the two became one, and he was the one. So it would become Mr. and Mrs. John Jones, for example, not Mrs. Mary Jones. It was Mr. and Mrs. John Jones. She lost her whole name. Well, that's okay, I guess, for the Brits, but it didn't work out well economically, and it certainly violated the treaty. So then people say, well, how in the world did we get French law from Mexico? The answer is the French used to own Mexico. They ran it. Actually, they didn't run it. The French owned it, but it was run by the Habsburg family. Australians. Not Australians, Austrians. The Habsburg family owned a lot of Europe as well. And they had one of the kids, Maximilian, running Mexico. They had another kid running Brazil at the same time. Well, after a while, the Mexicans decided they didn't like the French running the place, and they were going to throw out the French. And Maximilian said, I am not leaving. True type of Austrian, you know. The Austrians were everywhere. They used to be, one of them, governor of California not too long ago, Schwarzenegger. So he didn't want to leave. He said, I'm not going to leave. They'll have to kill me. Yeah, they did. So the Mexicans killed Maximilian and got rid of the French. But they kept French law in Mexico. And when we had the Treaty of Guadalupe Hidalgo, because they had the French law, we then adopted a lot of French law here in Arizona by reason of the treaty. So there you are with a nice, interesting history of French law. But it's not automatic. So you don't move, for example, from New York to Arizona and suddenly everything you have is in community property. Because when you move from New York to here, as husband and wife, you earned and owned the property under the common law. If you earned the property here in Arizona, it would be under the French law of community property. But now you've imported this British law property and you've brought it here. Who owns it? The answer is typically the husband. So what we want to do is change all of this British concept stuff and make it into French community property law. So we use a community property memorandum. And we convert this property from whatever it is into community property. It's called transmutation. Sounds almost like one of those awful films out of the Middle East. Well, to illustrate the differences, I'm going to go through the major dangers of joint tenancy. And in doing that, I'm going to deal with capital gains tax as well. I'm going to combine the two together. There are 4 major dangers that I'll talk about, and I'll talk about them one at a time. The 4 dangers are capital gain tax, gift tax, loss of the asset, and the conflict with the owner. So let's get first into a quick review of what is capital gain tax. Well, you take the market value, that is, whatever it is it's worth today when you sell it, and you subtract the basis. The basis is what you paid for it with adjustments. And there are a lot of adjustments, and this is not a tax class, so we're just going to say whatever you paid for it. So we have market value minus basis equals capital gain. On that capital gain, assuming you have a profit, if you have the capital gain, you're going to send a portion of it to the state and federal governments. Now keep in mind, if you bet the wrong way and you have a capital loss, the governments do not in turn send you a portion of that loss. It's a one-way street. You pay them, they don't pay you. The first example of three, we have John and Mary, joint tenants, both living when they decide to sell this asset, whatever it is. It doesn't make any difference from my example. Their basis is $10,000. The market value is $100,000. They sell it, have a $90,000 capital gain, and they're going to send some of it off to the government. Used to be they'd send a lot off. It's less now, but still they're going to be sending some. Wouldn't it be nice if I could cut in half the amount that they send to the government? And of course, everyone's going to say, well, that would be wonderful if you can cut in half what we're sending to the government. Well, I'd like that. And you'll notice that there's a gold bar there, and above the bar I call the facts. And here we've got John and Mary joint tenants, both living, decide to sell. I will change just one of those facts, just one, and I'm going to cut in half the tax. Now I know what you're thinking. I've been talking about community property. So most likely what I'm going to do is change joint tenants to community property. But it isn't true. What I'm going to do is leave it as joint tenants, but I'm going to kill John. Now we have John and Mary joint tenants. John dies. Mary sells. Well, let me tell you a little bit about joint tenancy. This is a common law form of owning property. Under this form of owning property, everyone owns all of it, but they only own a portion. In this case, there are two joint tenants, so each owns 50%. If there had been four joint tenants, each would own 25%. But here we've got John and Mary, each owns 50%. Get out your calculator, because what's half of $100,000? Right, $50,000. Well, John's basis changed from what he paid for it, that was half of the $10,000, that changed to market value. But only his half of the market value, his half being $50,000. Mary, however, owns the whole thing, but the basis has changed. So to get Mary's new basis, you take John's basis of 50, her basis of 5, for a total of 55,000. We subtract that from 100,000, and you now have a capital gain of $45,000. You see, the old one was 90,000. This one's 45. We just cut in half what the tax is. Well, it can get better. But first, I have to do something that only we lawyers can do. While there are some folks who believe that it's a different profession, it isn't. It's we lawyers. I'm going to resurrect John. And while John is alive, I'm going to change that John and Mary joint tenants to John and Mary community. However, John has served his purpose, so I'm going to kill him again. Now, John and Mary community, John dies, Mary sells. The market value still is 100, but look at the change in basis. Instead of going to 50,000, it's gone to 100. When you subtract 100 from 100, you get nothing. And so you don't have to pay any capital gain tax on capital gain that you have, which is community property. Well, we can do this in Arizona and the other community property states. But if this same thing had happened in New York, for example, they would not get this complete change of basis. Mary would still have the $55,000 basis. This again is available only in community property states. So you can see why it is we want to change, as part of the estate planning, we want to change everything to community property. Gift tax. Well, let's see here. I'll tell you a sad tale, because this is what I see most often. Let's say we have John and Mary, joint tenants. John dies. John always dies first. Mary says, well, I own the house completely. No probate or anything, because that's inherent in the joint tenancy. But I want to make things easy for my only son, Billy. So what I'm going to do is I'm going to make it Mama and Billy joint tenants. So she gets one of these deed things and she fills it all out. She signs it and she notarizes it and she takes it down to the recorder and she records it. And now the official title is John and Mary joint tenants. Let's assume that the house is worth 100,000, 200, doesn't make any difference. 100,000 is easier for my example. She owns the house, it's worth $100,000. She just made little Billy a 50% owner. Is that a gift? Yep. Now the big question is, since she's allowed to give $13,000 to Billy under the gift tax law, and she gave Billy over that, she gave him $50,000, does she have to go file a 709 return? That's a federal income tax return. And the states also have one too, so you really need to file one with each. The answer is yes. She may not have to pay any tax, most likely won't, but she still has to file the gift tax return of 709, or she is now a criminal. It is a crime not to file the tax return. Just like it's a crime not to file your 1040 income tax return, it's also a crime not to file your Form 709 when you give half the house to Billy. So you have a potential gift tax problem. You also have another little problem of losing it. You can lose this because Billy's a bum, for example. Let's say that Mama didn't want him to be, out on the streets. And that's why she gave him the property, and it's Mama and Billy joint tenants. Oh, but Billy, although he's now 55 years old or so, he doesn't have much in the way of a retirement plan because, well, you see, Billy's never really worked. And while that's been fine for the 55 years, if ever he needed money, he'd call Mom. He does realize he needs some sort of financial plan once he hits retirement age, because since he's never worked, he doesn't even get Social Security. Oh, what to do? Well, he has a plan. He now has an asset. He works his way by getting a ride to Las Vegas. When in Las Vegas, he shows the casino that he in fact owns half the house. They can go online and they can see at the county recorder's office that this guy does own half the house. And do you think he can put up half the house for his winnings? You see, this is his financial plan. He's going to go to Vegas, use the house for collateral, make a killing, and be able to live happily ever after. Quite a financial plan. The problem is, those casinos were not built on winners. They were built from people like Billy. And Billy, when he joins the other losers, is going to have to face this problem. He has to turn over his share of the property to the casino. Now here's the big question. Is the owner of the casino going to move down here to move in with Mom and become a joint owner? Or do you think the casino wants to sell the place and get its money? One guess is all you're allowed. And if you guess moving in, you go to the back of the class, because the casino will force the sale of the house, and now neither Mommy nor Billy have a place to live. What happens to Mom's half? Well, Mom's now got the value. She's got the dollars of the half, less the costs of sale, etc. But she doesn't have a place to live. she's now going to be in the market for a place that will have a market value less than half of what she had. Well, let's suppose the kid's not that bad. He just has been part of the recession era, and everything he has gone into bankruptcy. The bankruptcy law requires that anything you have, any asset, has to be named and put into the bankruptcy. Now, there's an incentive for the bankruptcy trustee here in that they get a percentage of what's ever there. Most of the bankruptcies are no asset, so they don't get much. But whenever they see an asset, do you think that they're going to take pity on Mommy? Do you think they're going to say, oh, gee, Mom, you're not going to have a place to stay. I'm not going to take this case, and I'm not going to take in Billy's part and make you go out on the street again? No. No, actually, they're going to sell the house just like the casino owner, and Mom's going to be out on the street just as if the kid had been a bum. Just unfortunately, he went into bankruptcy for whatever reason, but he owned half the house when he did it. Then you've got the successful kid. Knows everything he's doing, worth millions and millions of dollars. He makes some financial major mistake. He might have flown his private jet into some major building, destroyed blocks and blocks and blocks like 7-Eleven. 7-Eleven? No, that's the store. Like 9/11. So he destroys all these blocks. It exceeds everything he has and all the insurance he has, etc., many times over. Well, what's one of the things that he has? And the answer is Mama's house. And where are we again? Well, Mama's back in the same spot as with the bum and the bankrupt, even though this kid has been successful. We do have another problem. Let us suppose that Billy was an angel when Mommy did this. And after a little while, Billy became like this fellow here that we have, more of a hell's angel than a real angel. And now we have a conflict. Can Mom sell the house because it's Mom and Billy joint tenants? Can she go sell this house because she'd like to move to a smaller place or move out of the retirement areas and go to some desert place like Quartzsite? No, she can't sell. Suppose she says, well, I do have a mortgage and the mortgage rates are down lower than they've ever been. I'd like to refinance it. Or even if the mortgage rates aren't down, she says, I'd like to refinance it, take the money, take a worldwide cruise. Can she refinance her house without Billy's consent? No, she can't do that. There's yet another problem with joint tenancy. Let's suppose the reason Mommy and Billy stopped talking. The reason is Billy married a woman that Mama can't stand. Now, I know this would never happen in your family or any other family that you know, but you've watched soap operas. You do know that it happens. And after a while, Billy decided Mom was right. This is not the woman for him. And they end up in a bitter divorce. Now let's see here. We have a future ex-wife. We've got Billy. Future ex-wife wants half of whatever Billy's got, right? What's Billy got? Well, among other things, Billy's got one half of Mom's house. So now we've got the new, or the soon-to-be ex-wife, demanding one half of one half, which is 1/4. Looking into the future, do you think the future ex-wife is going to want to move into the spare bedroom with Mom? Or do you suppose she's going to want cash, which in this case, assuming a $100,000 house, she's going to want 25 grand to have her fair share? My advice, your kids or beneficiaries, whoever they are going to get their dirty little grubby hands on your assets soon enough. There's no reason for you to give them to their bankruptcy creditors, to their gambling creditors, or to their future ex-spice. You do know that spice is the proper plural of spouse. No. You should maintain control of your assets until the day you die. After that, they can put their dirty little grubby hands on your things. You really won't care. A device or document that we use in wills, this is not used in trusts. We use a beneficiary deed. Let me repeat that. We use a beneficiary deed when we use a will as part of the estate plan. We do not use a beneficiary deed with a trust. And the reason is that with a trust you have much more flexibility and control. But with a will, you don't have to go through probate if you use a beneficiary deed. And we use this for property in Arizona. It's one tool of a plan. It is not the whole plan. But the essence of what it says is, I give my property to Aunt Tilly or to whomever, and upon my death, that's when she gets it. Until my death, actually you can record another beneficiary deed, and the subsequent beneficiary deed will take precedence. So you can first give it to Aunt Tilly, and then later you can give it to somebody else. Somebody else's deed will take precedence. Let's look a little bit at income planning. Estate planning to be sure. The question is, will you outlive your income? Keep in mind, people today are living longer and longer. I have 2 paintings in my office that were done by my grandmother when she was 97. And she didn't even learn how to paint until she was 93. And she did that when she was on the Love Boat. So, some of us who are looking at this, and I have clients that come in to me and they say, I'm 80 years old, I'm too old to learn something. Not true. You could go on a Love Boat cruise and you could learn how to paint. And people are in fact living longer. But there's some unfairness about this. Women age 50 have a 51% chance to reach age 100. Incredible. Women age 50 have a 51% chance to reach age 100. And men? Again, we are discriminated against by nature. Men have a 19% chance. 19% versus 51. I don't think it's fair. Something should be done about this, and I've proposed changing the law, but so far I've been unable to make that successful. But this does bring us to the issues of long-term care, because people have several things that they have in mind. The big fear, I will end up in a home. And I can rest you some sort of relaxation here. The statistics are you probably won't. Going back to the Pareto rule, 80-20, the latest statistics I saw were actually 78-22, but figure 80-20 to make it simple. 80% of us will never go to a nursing home. There's good news. It's not like everybody's been trying to tell us that everyone will end up there. 20% of us will. Well, of that 20%, most will not be there very long. We'll go there and we pass away. There are very few that will be in a nursing home over an extended period of time. So one of the great fears people have that you're going to end up in a home may be misplaced as to the gravity of that fear. The second myth that I would like to blow up is that Medicare will pay while you're in the home, in the rest home, in the group home, whatever it might be. And the answer is no. Medicare will not pay. You will end up paying it, and if you can't pay up, then you're going to end up being on some sort of a program that's in essence welfare. In Arizona it's called Altax, and but in other states it's called something else. You will end up on a state-provided program, but that's only after you've spent everything that you have. Now, everyone says to me, well, that's terrible. But no, actually, when you look at it, many of these group homes and places that you fear we're going to charge you so much money are reasonably priced and will be very close, and in some cases less than the amount of money that you're spending right now every month to live. Keep in mind, you're not living for free. It's costing you money for everything that you're doing. and that money is just going to be spent on something else if you have to go to a group home or some of these assisted living facilities, something like that. Another plan that people have is, I'm going to give things away. Well, that plan stopped in 1993, the year Bill Clinton became president. And he made a law in October that was retroactive to January 1, which was before he was even president, that made this plan no longer effective. It was done prior to 1993, and it was very effective at that time. In today's world, it doesn't work. There are things called look-back features, and well, I'm not going to get into the technicalities of it, but if you give things away and then apply for state assistance of some sort, they will look back to see how long ago you gave things away and how much you gave away, and then there's a formula as to when you can apply and when you can't. And I've had people say, well, if things are bad, I'll call Jack, referring to Dr. Kevorkian. Well, first of all, of course, as you probably know, Dr. Kevorkian died. But even before he died, he wasn't taking calls after he got out of prison. Worse than that, at the time that you'd probably want to call good old Jack, you might not be in the condition to be able to call him. So thinking that what I'm going to do is one of the techniques that are listed in the book Final Exit, which is an interesting book to read, in essence, how to commit suicide without anybody interfering, you might not be in a position when you'll actually be able to do that. Do you have a pet? Well, what happens to pets? All too often, the pets are killed. That's unfortunate. And you'll see that I have on this slide a variety of different pets, one after another, different pets that we have, everything from the cute little goldfish and things all the way up to the pet snake. I even have a client that has a pet dragon. True, a pet dragon. It's called a red-bearded dragon. It's maybe 6 inches long. Cute little thing. But you could have a pet, and if you don't provide for your pet, the chances are it's not going to do well. You need to make arrangements. As a matter of fact, and this is a tip to all pet owners, you should know about something called the vial of life. And this is where you have in a regular pill vial that you would get at the drugstore when they give you a prescription. You put in there a note, and in the note you give the name of your pet, who the veterinarian is, who to take the animal to in the event that you are found, things like that. So if you're found at the scene of a car accident, for example, one of the things that the local fire department is taught to now look for is this vial of life. So that if there's a pet with you in the car, they automatically are going to look. But even if a pet's not with you, they'll be looking, because if you're going to the hospital, the pet at home or the pet in your car still has to be taken care of. And this is one of the things that you want to take care of as far as making arrangements to care for your pet. If you don't know exactly who to contact or what to do, there's a group called Best Friends Best Friends Dog Club. And while primarily for dogs, they do have references that if you happen to have cats, birds, tortoises, that sort of thing, they'll be able to steer you in the right direction so that your pet will be taken care of. Well, most of the things we've been talking about deal with legal issues. And I cannot encourage you enough to go see somebody with a legal education and experience. The law degree is a doctor of law. It takes 7 to 8 years to get. It's not something you can pick up in a weekend or a week's school. Legal documents, poorly drafted, such as wills or trusts or powers of attorney or other legal documents, will always cause problems. And particularly in estate planning, think of this. If you have a contract and it's not well written, you can always change it, or you can explain to a judge, or you can do something. But if you have a power of attorney and you're in a coma, or you have a will or a trust saying where things go. You can't change what's written. It has to go that way. And if it is not properly written, then it's not going to go the way you want it to. Things you should be aware of and be afraid of are things I call leper's bells. As soon as you hear these words, trust me, you don't need a lawyer. Trust me, I'm working with a lawyer. Trust me, I'm a registered senior specialist. Of what? There is no registration place for senior specialists, for example. But you'll see this on business cards all the time. Or you'll see, trust me, I'm a certified elder advisor. Certified by whom? And the answer is nobody. But it sure looks good on a business card. You have a real danger when you're dealing with an honorary attorney. That's this little fellow in the top right of the screen. You'll notice how he's trying to put the pieces of the puzzle together. Well, honorary attorneys are not trained in law. If you want to change this slightly to a little different example, the next time you're taking a flight, how would you like to have an honorary pilot? Somebody who's not trained in flying. Well, I've been fortunate enough that I've had honorary pilots. The good luck has been that they've been sitting next to me back in the passenger compartment and not up front flying. But I've been sitting next to people who knew everything in the world about flying and the aircraft. And I would ask them, are you a pilot? They'd say, no, but I did read airport once. Well, there's a difference between going through all the training it takes to fly an airliner and the training it takes to become a physician and the training it takes to become a lawyer, to get all the pieces put together. That's just the initial training. And then you need experience in actually doing it. Worst of all, honorary attorneys have no malpractice insurance. Honorary pilots don't get insurance either if they try to fly an airplane. In fact, unlicensed drivers don't have insurance when they're doing it. So once you're into a situation where the person is not trained, it becomes too libelous, too much liability for an insurance company to bear the risk. And they say they are not going to insure people who are not trained. And if an insurance company is not going to accept that risk, certainly you should not do it either. And that includes a do-it-yourself kit where you're making yourself the honorary attorney. At my office, we offer estate plan packages, both trust and will. And you'll see on the handout that accompanies this CD, or you can print it out in PDF on the CD itself, a list of the documents that we include. We also offer a free consultation to new clients, whether we're talking about wills or trusts, probate, guardianship, estate administration, and, if need be, litigation. Because there are times that you just cannot avoid the heart surgery, which is what I call litigation. Litigation takes forever. It's very, very expensive, and it is ultimately the worst thing in the world. But nonetheless, there are times when you'll have to do this. If that's true, then we offer litigation services as well. Thank you very much for joining me. I hope you have enjoyed all three portions of this and that you've learned something about it. If you would like to contact our office, you'll find we have a very friendly staff. We're happy to talk with you. We have a very short information sheet that we would need you to complete prior to coming in. It'll probably take you all of 5 minutes, or you can complete it when you come to the office. And then you would be set up to meet with me or one of my associate attorneys, but most likely me. And then we would see what it is that you need and provide that for you. Again, thank you very much for joining me.